Good morning, Mr. Castillo.
Señor Castillo. Buenos días.
Buenos dias. You're charged, you have two very serious charges. Your first charge is burglary of a habitation. Your next charge is interference with the emergency request for assistance. The case that you are in front of me on here is the misdemeanor interference case. So it appears to me that the cases were filed on February 9th. It looks like you were given a general order bond on that day. We appointed you a lawyer on the 14th, so it's been a little less than a month. What happened in this case? Because I have no idea.
I was going to say that. Thinking about it since we're here and everything.
This is where the case explodes. Burglary is bad enough, but throw in shattered glass, police dogs, and a suspect caught crouching in the shadows, and the danger level spikes off the charts. But here's the real shocker. It's not just a break-in charge. He's linked to a radio jamming device, a tool straight out of high-tech crime playbooks. So ask yourself this. Should wielding cutting-edge gadgets in a crime pack the same legal punch as carrying a weapon?
Because I think there's a good argument, at least, that I come up with.
On February 8th, 2025, the officer was dispatched to a residence regarding a burglary alarm activated. The officer observed an unknown male wearing a black hoodie in the backyard of the residence, and the dispatch advised the resident was not home. The officer observed the male jump the back fence, and K-9 arrived and advised that forced entry had been made through the back door with shattered glass door. The upstairs of the residence appeared to rummage the roof, and officers located property later confirmed to be stolen from the residence, as well as a black hoodie, a black backpack, and a pair of pants. The K-9 located the defendant hiding, and the defendant admitted to being inside the residence during the time of the burglary, but would not provide further information. The complainant stated approximately $500,000 worth of jewelry was stolen, and a radio jamming device was located inside the black backpack, and it was discovered that the officers within the vicinity were unable to use body-worn camera.
This was on, I think, was this on, because of that radio jamming device, it was the interference with the emergency request for assistance is based on the jamming device that interesting.
Yes, that's what using the frequency jamming device to prevent communications between officers.
So it says here, February 8th, did then and there unlawfully, recklessly render unusable an electronic communications device that would otherwise have been used by Officer or by El Lejeune to request assistance in an emergency, namely burglary of a habitation, and said request for assistance would have been made to law enforcement agency, namely West University Police Department, who is using a radio frequency jamming device to prevent communication between officers. In this case, the device was actually used to disrupt communication. Was it not?
The officer said that within the vicinity, they were unable to use body cams, key fobs, or unable to transmit information through the radio.
And we know, or I guess you're saying that he had the device on him.
It was in the black backpack that they found, the officers found, and they initially saw the male wearing the black backpack.
Hey, Judge, so two things. I don't know about the wearing the backpack part. I know they found the device in the backpack. My recollection might be off, but I don't think he had it on him. I don't think.
Well, he's got care custody control because it's right next to him.
That's the thing. I don't know how where they found that. They said he was hiding, but I'm not sure where they found that backpack. First of all, secondly, the way they figured out, hey, this is a jamming device, is because they turned it on from the backpack and they were close to it. Hey, all of a sudden my stuff's not working. Come here. Hey, we're close to it. It's not working. So this was after the fact that they figured out it's a jamming device. They didn't say, hey, jam this or have this problem. They started playing with it. And
They said he did.
no, that's the problem. He did not. They played with it. That's how they found out it's a jamming device. They turned it on, which comes up as
Yes, they may have done that at that time, but also in the search, when they're looking,
During the active investigation, it was seen that their body worn cameras and their ability to unlock and lock police vehicles was affected during that active emergency investigation.
And
They're saying it was you.
right, they come back and say, hey, did we have trouble with it? Yeah, we had some trouble. They're turning it on and that's how they figured it out.
But you should be able to see all that. Pull the records,
Right.
because if they have body cam
Oh, yeah.
and they're using it, it should show a
It
disruption.
doesn't show that he was the one that it was actually turned on. They didn't show.
I know that, but you're gonna see the actual, you should.
Oh, yeah, you're right. And he's not the only person that was involved in this allegedly. So saying that he's the one that turned it on is gonna be an issue. There was somebody else that was seen that they're not mentioning. So did he turn it on? Did the other person turn it on?
I mean, this news,
He's being charged.
is there someone else that was
Please look at
there?
the report, because I'm not just making this up.
And I'm not saying you're making it up, I'm just saying you did, it doesn't say that.
Which calls into question, why isn't it in the news?
We have no R.
Does it say whether they were able to recover the $500,000?
They recovered it all, Judge.
They did?
Evil Warren does say that Mr. Cuthbert was admitted being inside the house with another unnamed male and provided additional suspect information.
But no other mail was on the scene.
They only found Mr. Cuthbert was hiding at a property down a couple of blocks, I believe, from the canine officers found him hiding.
But the backpack is with him.
Yes. Well, the backpack was found,
At the front, it was found at the front of the residence located on Westchester Avenue, as well as where they found him.
Versus with him. Big distinction. And the second person I'm talking about was supposedly seen on the surveillance video. So there's a mention of the surveillance video showing two people walking.
So to be clear, Your Honor, the property, including the backpack with the frequency camera, was found on Westchester Avenue. Mr. Contreras was found hidden underneath bushes at a residence on Rutgers Avenue. So it wasn't with him when they found it.
Versus what they initially said. Now we're getting more details.
How did you link him to the one who's using the device?
so the way that we would meet him is that he was seen wearing the black hoodie, the black pants, and then later the same clothing along with the backpack with the jamming device inside of it, those are all found together.
You say that was he wearing that?
This is a courtroom slugfest. The defense fires back. Proof he actually used the device. The prosecution won't budge. Possession equals control. End of story. But then the plot thickens. Surveillance footage teases a second suspect lurking in the shadows. So what's the verdict? Does finding the device near him seal his guilt? Or does the ghost of an accomplice blow the whole case wide open?
Initially, in the DIM, it does not say that he's seen wearing the backpack, but his other clothing was found under the
Because
backpack.
the DM says he was wearing the black hoodie, and as she mentioned, the clothing, and jumping over the fence, they observed a male wearing the black hoodie, and they found that hoodie along with the backpack. And they terminated their search after an extensive search through the mail, so they're unable to locate anyone else within the perimeter that they searched.
There is surveillance with the second person there?
Yes.
Yeah. How do we know that the other person didn't use it? I mean, I get it, that all of it's together. We don't know who put that there. How do we know the other person didn't put it there? I know that he's wearing it, but
And Judge, this other case is still pending. This isn't handling the
I don't care about the Burnham. My concern is this, is that, I mean, how do we link him to operation of the device? Why don't we do this? Why don't we have a full-blown hearing?
Yes.
Look through, you know, go through everything. You go through everything. We can have it tomorrow. See what you can, you know.
I think that's the right decision, so we can have it on both of us.
I'm not opposed to finding no PC, right? I want to know if you can truly link them or not. You know, I'll give you a day, come back tomorrow and see what else you have. If you have nothing else, then we'll go from there. Sure.
full-blown hearing for PC. They could always look.
Please give everything that you have access to, give it to counsel so he can take a look as well. He can take a look at any kind of videos, you know, take a look and we'll see. Okay. I mean, all we have now, he's wearing a hoodie, he's wearing pants.
And then they found the bullet with the back.
Judge, they could always refile this. They don't have to dismiss it. They could always refile.
But you're springing it, I mean,
Not springing it, it's no fair.
just, I'm gonna give him a day.
Okay.
I mean, he's not going anywhere anyways.
Okay, fair enough.
Let the Berg have upstairs, he's stuck here regardless, so. Yeah, I wanna make the right decision, so.
Fair enough, Judge.
Be diligent.
Is there a certain time you want the hearing?
Whenever you want.
Okay, sounds good. Appreciate it, Judge. Thank you. Judge, may I reapproach on that, Mr. Castillo?
On who?
On the hearing tomorrow, Mr. Ignacio Castillo.
Okay.
Judge, just to be honest with you, I'm a little confused as to what kind of hearing it is tomorrow, but the more I think about it, it's like if it's an actual hearing on the record and we're trying to figure out what's going on, I mean, do I have a right to subpoena some of these people to come and testify regarding this or
Well,
what?
then if you're gonna start subpoenaing people, I have to give him 2 weeks.
Right, we have a hearing on the
I was
record.
just gonna, you know, there's video they're saying surveillance, and we would make sure that there is another person there that is.
Using the minutes in the office report, which are both sworn statements, would be enough to establish probable cause. So I don't think we need to subpoena anybody to be here.
Which we've already done right now, so I don't understand what the hearing for tomorrow is gonna be different.
I think more to the point, we just need time to further review the OR so tomorrow, because it is 8 pages and there's a lot more details that we need just some time to review, just to further determine what our probable cause is. So just tomorrow we can revisit this and we have a full understanding of the OR.
Okay, so we would be hearing stuff, but I don't have a right to.
I'm giving them a little bit of time until tomorrow. That's all,
Okay.
Ricardo.
Okay, I'm just throwing off when we start talking about hearings. It's like, okay, are we gonna be on the record? What are we doing?
I hadn't planned on it. If you want it on the record, we can.
Can I talk to Richard, see if we could work this out? Right, I mean, because, like, if we're gonna roll it, I mean, I wanna subpoena some people.
Leave today, give him I need to look at this more. It's kind of the 1st scene of it. If you, I'm not in a position to plead today, just give him.
No, not plead it. I mean, just look at it, see if you think you have probable cause to.
Okay. I mean,
That's what we're asking for. Let's talk about it. Let's talk
I
about it.
mean, we can.
I gotta roll, Ricardo.
Yeah.
Oh, okay.
I gotta go. Can't just sit here and wait.
Well, if that's the
for
case,
an hour,
if
45
that's the case,
minutes.
can we set it for a real hearing and also subpoena people 2 weeks out? Let's do that.
Oh, that's right.
Okay.
Let's pick a day. Let's pick a day.
Sure.
Let's see. Ignacio Castillo, CAS.
Bond condition.
Let's do, we are at 12.
But they were getting filed, so you know when to come in? Okay.
Yeah, I'll subpoena them.
That's it though, right? That's it? Okay.
Can we do the 28th?
Whatever day you want. Oh, any day but
27th, I'm sorry, I got the wrong one.
That's the day.
Oh.
Mr. Postel, come up. Sir, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand something very important, that this will go on your record as of today, and it's going to be there for the rest of your life. You can never take this off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? So you give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So there's no turning back once you plead guilty.
Look at the shift. This case just detonated. We're no longer just talking burglary and tech tricks. Now it's DWI, weapons charges, and probation violations piled on top. The stakes are climbing fast. So here's the burning question. Will tomorrow's hearing finally rip the truth wide open about the jamming device? Or will the whole mess be left dangling in doubt, fueling even more chaos?
I'm going to find you guilty. Was it a gun?
Yes, Judge, the firearm.
The weapon will now be forfeited to the state. You will not get it back. Do you understand?
Yes.
Okay, good luck to you, sir. Or how do you plead?
Guilty.
I'll find you guilty, sentence you to it. Good luck to you, sir. Thank you, Josh.
Question?
You can run it. Good morning, Ms. Rodriguez. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
Yes, Judge. On March 4th, 2025, the officer was dispatched to a minor accident at 1700 block and is required to serve any effective. The officer made contact with a witness who stated she heard and saw the defendant with a firearm assault on the vehicle, sideswiped a parked motor vehicle. The officer noted the vehicle was parked incorrectly facing the opposite way. The witness stated she believes the defendant is intoxicated, and the defendant stated she hit the motor vehicle while driving as she took her eyes off the road when trying to retrieve her cell phone, which fell to the floor. The defendant stated she remained on scene because she wanted to make it right with the owner. The officer observed slurred speech and swaying, and the defendant admitted to having drinks earlier in the day. Standard field sobriety tests were conducted and the HGN test was began, however, was suspended at the defendant's request due to high winds. The defendant was placed under arrest for suspicion of DWI and was transported to the jail. Standard field sobriety tests were then conducted at the jail. HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read DIC and consented to provide breath. The first sample came back deficient and the second sample came back unacceptable. A blood fit warrant was signed and executed.
Well, ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or any illegal drugs, your bond will be revoked. You'll go into custody. I'm also now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, then likewise you will go to jail. We send notice to DPS of this restriction and this requirement so that if you're caught driving a vehicle, it doesn't matter where it is. Every officer in the state will know that you're required to have an interlock. So if you're caught driving a vehicle, they will arrest you. You've got a great lawyer here. Listen to him. He'll take care of you because you have him. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him. He'll tell you when you have to come back to court. For now,
She's already had the interlock installed.
wonderful. Okay. So you're just, well, not much of anything. Just stay in contact with him. He'll tell you what to do. We'll just have you sign a reset and then you're on your way. Okay.
Good morning.
Hi.
And I tried to call the holdover judge, but I don't know if I have the right number. 2689, is that right?
What number can you call over to talk to someone?
Which should have been,
Who is it?
Oh, it's on, let me get to him. Sorry. It's a brand new one. He's got 2 cases out of Louisiana. It starts with an S. It is.
Oh, I thought you were. Oh, he refused, right?
Oh, he refused. I guess we got to bring him out anyway.
Yes.
It's 31.99.
3199, Greg.
3199.
Yeah. And then he's a refusal from yesterday, or from, I think it was yesterday.
Okay, I just got appointed today on it. Do you want me to call first and then just come back on?
So yeah, just to give you a brief heads up, he's on probation for an evading in a motor vehicle upstairs, 42nd,
So he's got a
From-
local.
23, 310. He picks up an assault. A failure to ID is a fugitive, and now we have this fugitive case.
Okay, so he's got locals. He's probably not going to sign anything.
He has not made bond on the assault. He has not made bond on the probation, so it looks like we're kind of in a holding pattern for those two, by the way. So
Do we know the court date on this?
let me see.
On the evading judge, it's
Tomorrow in the evading.
So
42nd.
you want me to just talk to him and then we roll him to Friday?
It's up to you. You talk to him, see what you want to do, whether he wants to keep the refusal, whether he wants to, whatever he wants to do. And then
Okay,
just let
well,
me
if
know
he's not gonna
whether he
make
wants to
bond
get a
on the
bond,
local-
whether he wants to waive, whatever he wants.
Okay, if he's not going to make bond on the locals, but if he insists on asking for a bond,
Sorry, I will let you know, there is a pre-signed waiver on the option.
Oh, pre-signed waiver.
no, there is a pre-signed waiver.
Oh, I can't give him a bond.
Okay, let me see if he's going to keep that pre-signed waiver, and I'll jump back on.
No. That's not, once there's a pre-signed waiver, that's it. You've already waived. You waive by signing that agreement, whatever agreement you sign.
So, but you're saying
Louisiana.
he signed a pre-signed waiver of extradition, so there's nothing for me to really do except track.
Correct. Right. Just
Okay.
advise them we're in a holding pattern until you take care of all the locals. And at that point, once all the holds have been lifted, at that point, we give Louisiana up to 30 days to come get you.
Okay.
So also note, if we're gonna go for a kind of regarding that central agreement, I'll let you know. That one can sign the 14-day waiver.
Sorry.
Okay.
So from the pre-signed waiver date, then I should just keep the 15-day reset and see if anything happens, great. If nothing happens on the locals, then whatever. See what I'm
Yeah.
saying?
Yeah, so if he wants to waive today, just let us know and we'll write it up.
Okay, and what would that reset date be?
It's gonna be a reset to track locals, so it looks like he has his
So
next.
it'd be Friday anyway.
Well, he also has an ADR on the 17th and has a big bond on.
So yeah, the failure to ID, both of those are in court too. They're set for, one's set for yesterday, one is set for the 17th. So we could probably, the 18th,
18th? Okay.
Yeah.
Let me,
3199.
yeah, thanks. I'll talk to him right now. Thank you, Judge.
Let me know when you're ready. Mr. Wood, you were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 5th, 2022, the complainant told officers that the defendant was terminated for intoxication and attendance issues. The complainant believed that it was clear to the defendant was not to return to the physical location of the business. The defendant returned a few weeks later requesting money from an employee, spoke with a manager to say his termination was not fair, and the defendant approached employees while they were on break, and employees stated the defendant was making them feel uncomfortable. The complainant told the defendant not to come back to the property, and the defendant stated he understood. Approximately a week later, the complainant was walking to his vehicle in the parking lot at the location, saw the defendant inside his vehicle. The defendant had snapped the side view mirrors off the vehicle.
So just a trespass, no.
Just try.
All right, Mr. Wood, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to this location. Do you understand? If I find that you've violated conditions, if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds for you. Your bond amount is set at $100 now. So he has not made bond, right? Okay. I will give you a PR bond today, Mr. Clark. I'm sorry, Mr. Wood, but I'm not going to give you another one. If I find that you're a danger to my city in any way, I don't care. I have a place for you. Do you understand?
Yes, sir.
So for now, what I'll have you do is, do you have a lawyer today?
I do not, Your Honor.
Do you have the ability to hire a lawyer?
Do not, Your Honor.
Okay, I can have you fill out an application for a court-appointed lawyer. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have in the bank, what you do for a living, any source of income, what kind of car you drive, money in the bank, stocks, bonds, IRAs, mutual funds, anything.
Got documentation.
Okay, well, no, I need you to fill out my application.
Yes, sir.
And then I'll have you sign a receipt with Victoria. We'll have you take your seat in the jury box. Do not leave until you sign our bond conditions. Okay?
Yes, sir.
Okay, come on. So can you file no going back to this location, please? No weapons.
As well.
Yeah. All right, good morning, Miss Lynn. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, sir.
Yes, Judge. On March 9th, 2025, at approximately 11:29 p.m., the officer was dispatched to a wrong-way driver call at 1623 South US 59 Freeway in Harris County, Texas. Upon arrival, the officer observed a vehicle stopped in a moving lane of traffic with multiple tow trucks around the vehicle in an attempt to box the defendant in. The defendant's vehicle ignition was on and the vehicle was in park. The officer made contact with a real witness who stated they saw the defendant's vehicle traveling southbound on the northbound side of South US 59 and that he and other tow truck drivers boxed into the defendant's vehicle at 4800 Main Street. The officer observed the defendant to have an odor of an alcoholic beverage, swaying and stumbling. Bloodshot eyes and disorientation were also observed. The defendant admitted to drinking 6 drinks at the Houston Rodeo and stated she was 4 out of 10 drunk. The defendant refused standard field sobriety tests. The defendant was read to DIC, and the defendant refused to provide a specimen. A blood search warrant was signed and executed.
You look her up to see if she has any prior DWIs.
She doesn't. She had no prior. Everybody is eligible.
Okay, Miss Lynn, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bombs. Do you understand? Now you have a lawyer. They will take care of you. I will waive your appearance because you have a lawyer, but it is your responsibility to stay in touch with them. If they tell me you've gone AWOL, you pick up a new case, become a danger to my community. I only have one place for you. Do you understand, ma'am? Okay. We'll have you sign a receipt with Victoria. You'll get with Fleischer for your bond conditions, and after that, you're free to go. Okay. Thanks.
I couldn't get here. And actually, Judge, I got a 2-year-old I'm running behind, but I'm approaching today, Judge, on this case. We did file. I got some emails and check stubs that we attached to the case because I'm pleading. My client has basically lost his job because you put an ankle monitor on him to where he cannot go out at night and he has to stay home for this type of offense. And it's a resisting arrest. Let me refresh your memory. I know you've had 1,000.
I remember.
Right. And so I didn't know all of this when a case comes in, the day before. I don't know.
Is this the one where he stomps on the person's
Correct.
head and the person's unconscious?
And so what I did was I told you, I said, Judge, there's a before, in between. We don't know, but we do know, as we all know, what happens at intake. Even when I was intake, there's a reason they declined charges. I believe Madam Prosecutor got up and said it was because he was unconscious, and you and I both know they would still accept charges, even if not for him. So I'm assuming.
I've seen crazier things. I mean, we had it the other day where a guy gets run over by a bike and they filed nothing on it,
I get
So,
it, Judge. I guess my whole thing is bond is to secure them coming to court. What we don't know, Judge, and I believe on video on Friday, what I saw was I heard a dim summary, and it's almost as though in my humble opinion, I believe the restrictions that are put on him are just too egregious. It's almost like we're convicting him of a crime. First off, that wasn't charged, and then 2, that wasn't even filed.
My thing is like, I don't want him to go out to bars. I don't want him to go out drinking. And so that's why I don't want him out in the middle of the night. So he's not going out and doing things that he shouldn't.
You do that in the day, Judge. I'm with you.
I get it.
No, and I get it. I said, Judge, after reading this, because I'm in both seats too. And so, yeah, it does. But he's now lost his
It's less
job.
likely to happen in the day than in the middle of the night for the
Like,
shenanigans.
but we can say that he works. And literally.
I told you, if you show me that he works in the middle of the night, I will.
I actually with it on his boss.
I told you, I'm okay with it.
Yes, sir.
I will have a GPS monitor on him, so I know if he's deviating from where he's supposed to go.
No problem.
If he's going out somewhere else, because the only reason I will let him out is for work purposes only in the middle of the night.
What if he has to go get Pampers for his baby? What if
He can do that during the day.
Well, I get it, Judge. I'm just saying,
At 3 in the morning.
I don't disagree. I'm just saying, I don't want the restrictions to be so tight to where if he stops for gas, then they're like, oh, he stopped at the gas station and he got gas.
Why can't you anticipate these things doing it
Well,
during
no,
the
I
day?
mean, Judge, everybody don't think the same. I'm just making sure that
If
if I don't agree with them, if you want to do the ankle punches, that's fine. I'm just saying, Judge, I think for this type of offense that we don't have assault charges for resisting, to me, it's a bit egregious.
They're telling me that they're going to file the assault charge.
It happened today, Wednesday. I checked Monday. That's why I didn't come in on Monday because I was waiting.
Please?
And and here's another issue with that, Judge, is because of what happened on Friday, I got some
Really?
other stuff.
I'm acquiescing to your thing.
So we're looking
I'm
at each other.
saying yes. I just want him to go to work.
Yes, sir.
That's it. I don't want him going anywhere else.
Yes, sir.
If he needs to get gas, if he needs to get groceries, this doesn't need to happen at 3 in the morning.
Understood.
Do it during the day. That's it.
Understood. Yes, sir.
I'm okay with him going to work in the middle of the night, but you need to let him know. I've got a monitor on him. I know where he's going.
Yes,
If
sir.
he deviates, I'm going to revoke his bond.
Yes, sir. For work, he also, when he goes to work, he works dealing with oil or something from my understanding. And so he does have to drive. I just want to make sure that if they were to say, oh, it looks like he's driving once he gets to work, it's because of the nature of his job. And we can bring proof, hey, this was what he had to do today.
Great, but if I find that he's at Club Punka City,
Yes, sir.
at 3 in the morning, I'm going to have an issue.
I understand. Yes, sir. I understand. I get it.
So
Before decision is made on those charges, I wanted to reject the complaint and get out of court. That's one of the delays. I'm just finding out about this.
Yes.
I mean, it's pretty egregious, it just, and I placed the restriction on so that he wouldn't go out, do anything he's not supposed to do in the middle of the night. I told him not to go to any bars, clubs, any places of this nature. And if I find that he does, and what she's saying is that he works in the middle of the night.
He said it on Friday too. He actually had a check stub to show you that day, but I wasn't here.
I'm not going to look, I'm not going to.
I wasn't here, so that's why,
Just let him know what the conditions are.
Yes, sir.
And that's it.
Yes, sir. So do I need to get it amended from her?
Right.
Yes, sir.
Yeah, and I'll waive the signature so he doesn't have to come down here, but
Yes, sir.
he's going to have to just let him know.
I will.
If I find that he's shenanigans, it's just not going to go.
I understand, Judge. I definitely understand. Thank y'all. I appreciate it. Thank you. I'll be in touch.